Okay, I will officially welcome everyone. Good morning, good afternoon, good evening, depending on wherever you are. This is Richard Lazarus and Jody Freeman welcoming you to our webinar, which will cover the Biden administration's climate, energy, environmental, and natural resource agenda. That's a mouthful, so we'll just shorthand it as the climate and environmental agenda. What we'll do is describe the Biden administration's regulatory plans, the priorities that it's working on, its agenda in Congress, and we'll do that in our usual tag team manner. Richard and I like to go back and forth when we do these presentations, handing off one section to the next. But before we cover the forward-looking agenda that the Biden administration has laid out, we need to go back and talk a little bit about the Trump administration legacy to set the stage for what you're now seeing roll out of the Biden team. So we'll do that, first starting with the Trump administration, then going to the Biden administration. And we're welcoming you to ask questions as we go, but we'll save them up and we'll take them all at the end of the presentation. Okay, so let me turn it over to Richard to start with our first section.
All right, thanks, Jody. So immediately after the November 26th election, Jody and I met. It was obvious to both of us the challenge facing environmental law was profoundly different. This was not same old, same old. This wasn't the latest political whiplash affecting environmental law. We've seen that a lot before. I mean, you go from Carter to Reagan, you go from Bush to Clinton, you go Bush to EPA, back and forth and back and forth. This one was different. Why? Because Trump's different, to say the least. No one before had campaigned on a promise, quote, to get rid of EPA, quote, in almost every form, quote, leaving only little tidbits. Not Reagan, not Bush, not Bush 2. More important, none of those others before who had campaigned to reform environmental law had complete control of both chambers when they took over. Conservative Republicans in both chambers of Congress were in lockstep with Trump on the environment. This was not like Ronald Reagan in 1981 having to deal with moderate Republicans in the Senate who had seniority, or like Bush 2, George W. Bush, who lost the Senate a few weeks in because when Stafford from Vermont left because of environmental issues and switched to independent. Trump had described environmental protection issue of our time, global climate change as, quote, non-existent, a hoax, a total con job. Senator John McCain had said, you don't use a meat axe when the scalpel reform is sufficient. Trump promised a meat axe, and it began on day one. January 20, 2017, it did not end until noon. January 20, 2021, with a rush that morning to sell oil and gas leases in the Arctic National Wildlife Refuge. Jody?
So to give you a sort of reminder overview of what President Trump and his administration accomplished in terms of rolling back environmental protections and climate regulation, we wanted to just remind you of a few things. First, the Trump appointments were quite significant. He appointed people like Scott Pruitt to head the EPA. Pruitt, as you recall, is a longtime climate denier. He was the Attorney General in the state of Oklahoma, and he opposed all of the major Obama climate rules. So he had a long track record of really being opposed to the mission of the agency he was appointed to lead. Likewise, people like Ryan Zinke at the Department of the Interior, Rick Perry at the Department of Energy, the suite of appointments sent a message, and the message was, we are not interested in regulating greenhouse gases. We are not interested in strong, strict environmental protection rules. We are not interested in protecting natural resources in particular, but we are supportive of fossil fuel extraction and of traditional energy. And that's exactly the agenda that the administration pursued. So you look to the appointments of an administration to see the signals that they're sending, and that we'll talk about that a little bit more when we talk about the Biden administration appointments, which are dramatically different from what we saw in the Trump administration. The other thing to mention beyond the appointments is what those leaders set out to do. So remember, Scott Pruitt started EPA and then gave way to Andrew Wheeler, who ended up prosecuting most of the Trump administration regulatory rollbacks at EPA. And Ryan Zinke gave way to David Bernhardt. Both Bernhardt at the Department of the Interior and Wheeler at the Environmental Protection Agency were shrewd operators, skillful operators who presided over a profound and unprecedented regulatory rollback. And we don't have time here to review those rules, but they are all up on our website, the Harvard Law School Environmental and Energy Law Program website. So you can look very closely at the almost 100 rules that the administration weakened or rescinded. I'll just give you two prominent examples, two or three, so you can recall what Trump sought to do with the most important climate rules. Rescinded the Obama era Clean Power Plan, which were the first ever standards to reduce greenhouse gas emissions from the oldest and dirtiest power plants in the country, and replaced it with an extremely modest rule that it would accomplish almost no greenhouse gas reductions by its own estimation. Also rescinded and weakened very significantly the historic fuel efficiency standards for cars and trucks to reduce greenhouse gas emissions for the transportation sector that Obama had put in place, reducing the 5% per year improvement in fuel efficiency to about 1.5%, a very significant rollback, and also revoking California's special permission, its waiver to set its own stricter standards for cars and trucks, and taking the legal position that California was preempted, was legally blocked from setting those standards. There are a couple other examples just to rattle off quickly, including rolling back methane standards for methane is a very potent greenhouse gas, as everyone knows, standards for the oil and gas industry, rolling back the venting and flaring rule for oil and gas operations for methane on public lands. And basically every major component of the Obama era climate agenda was rescinded or weakened in this way. Offshore drilling rules were weakened, which means a lot to Richard, who presided over the presidential commission that led to the strengthening of those offshore drilling safety rules. They were rolled back. And I say all this because it's important to recognize the scope and the scale of the Trump retrenchment. And it's also worth noting that most of it was actually not sought by industry. The car standards, the majority of the industry, not every auto company, but most said, you don't need to go so far as to unravel these. We just want some compliance flexibility. The oil and gas industry did not support the rollback of the methane regulations. So what was striking about the Trump era was not just the scale and scope of the retrenchment, but also the fact that it wasn't actually sought primarily by the industries themselves. The final thing I'll mention is just that the Trump administration did a number of stealthy, less visible things to undermine agency capacity, meaning the ability of agencies like EPA, Department of the Interior, to even perform their essential functions. They did this in a variety of ways that are hard to see, hard to legally challenge, including by undermining career staff, moving offices from Washington, D.C. to more remote areas, which would encourage staff to resign, which they did in droves. For example, when the Bureau of Land Management was announced to be moving from headquarters in DC to Grand Junction, Colorado, sidelining science by, for example, adopting a rule that scientists, academic scientists who had ever received an EPA grant can't serve on EPA advisory committees, which cuts out most academic scientists from serving, weakening the input from outside scientists, removing climate science or websites, and so on. A whole variety of ways the administration sought to undermine agency expertise, sideline career staff expertise, undermine capacity through budgeting and other techniques that are very hard to challenge in court. That essential weakening is something that the Biden team has to rebuild and overcome. And the very final thing to mention is that many of these Trump initiatives in the first couple of years were subject to litigation, were challenged in court, and the Trump administration lost those battles overwhelmingly. But they lost on procedural grounds. They lost because they cut corners. They lost because they announced that rules would no longer be implemented. They lost because they didn't observe normal legal procedures. But the substantive loss that mattered the most, the biggest loss the Trump administration suffered in court, was at the very tail end, as President Trump was leaving office and President Biden was being sworn in the very day before, when the DC Circuit rejected the Trump administration's legal theory about its very narrow legal authority under the Clean Air Act to set standards for the power sector. That was a real rebuke to the administration, not for procedural shortcutting, but because on the substance, the court rejected their legal view of their authority. Richard?
All right, so a new administration begins, as we all know, on noon, January 20th. But that's not the day the work begins. That is the day the new administration finally has legal authority to do something. The actual work begins months earlier. Both Jody and I were involved in the transition. Jody, I think, began in the summer. It is a leap of faith because the work necessarily begins before the election returns are in. For those on the Hillary Clinton transition team in November 2016, November 9th, they were ready to go, but their candidate had lost. They quietly canceled their Airbnbs and they went home. Happily for me and for Jody, I was on the Biden transition team for DOJ. Biden won. I was public on the transition. Jody was part of the private group. But the challenges the transition team faced were enormous. I similarly served on the DOJ transition team for Clinton Gore in December 1992. That's a long time ago. There's no comparison. Republican appointees at DOJ during 12 years of Republican administrations under Reagan and Bush were, not surprisingly, politically conservative, but they have been outstanding lawyers of enormous professional integrity. With few exceptions, they promoted the president's policies while respecting the Justice Department's traditions for excellence. And they were highly respectful career government servants. The need for pivots in pending environmental litigation in 1992 was minimal. Almost 30 years later, after only 4 years of Trump, the environmental agencies across the federal government were, as Jody suggested, they were devastated. The presidential appointee in the Environment Division is emblematic of what happened everywhere. At the Department of Justice Environment Division, the appointee running the division had destroyed morale. He had injected politics into hiring and promotion. He had met and settled cases with opposing counsel without career people present. He repeatedly sidelined, ignored senior career leadership. Environmental enforcement had cratered, both civil and criminal. Attorneys were not enforcing environmental laws because there were no referrals from EPA or Interior. They were instead using their resources to acquire land for the border wall. And they were defending rollbacks on poor administrative records because the client agency political appointees similarly were ignoring their career expertise, which is why they lost case after case after case. The job of the transition was be prepared for the January 20 handoff at noon. What needs to happen that first hour, that first day, that first week, and actually the first 100 days? That's the time horizon. There are two focal points in planning. One, get some quick wins. Make clear changes at hand, and we'll talk about that in a little bit. Second, lay groundwork for bigger changes needed before in a 2-year time horizon, a 4-year time horizon, and potentially an 8-year time horizon. That's the role of the first day, first week executive orders we'll discuss in a moment. And that's reflected in the Environment Division planning at DOJ. Two things, defense and offense. Defense, identify the hundreds, and I mean hundreds, of pending cases challenging Trump rollbacks that Jody discussed. Be ready to stop those cases as you can in their tracks as of January 20th. And then identifying all those cases and procedural posture, all the attorneys involved, all the deadlines, be ready to file motions as of day one to seek time so the new administration can make new decisions. Offense, to recommend changes within DOJ, not just defensive litigation, offensive litigation, restoring enforcement, new administrative priorities, climate, and environmental justice. But all those changes in the transition were done with an essential caveat, and that was consult, listen, and consider career expertise. You have to respect the career of public servants. It's no answer to a conservative administration that disrespected career to replace it with a progressive one that does the same. That's why during the transition, every meeting with career began with our heartfelt thanks for the service they had done over the past 4 years. Jody?
The Biden team sent a very strong signal when it first arrived by doing a couple things. One is the signing of the two major executive orders that Richard just referred to. One order that basically announces the new rules that the agencies will have to put in place, and another that looks forward to additional steps that he'll talk about. But in addition to these two major climate and environmental orders, the administration also made clear the importance of climate change by appointing very well-known, serious figures that have significant status to major posts, including Gina McCarthy, the former EPA administrator in the Obama administration, became the White House National Climate Advisor, presiding over domestic policy from within the White House to coordinate all of the agencies of the federal government who take actions on climate change. John Kerry, the former Secretary of State, became the U.S. Special Presidential Envoy for Climate, again, based with a seat on the National Security Council in the White House. And then there are a raft of appointments underneath them, both of them in the White House, including some very prominent people and additional folks who used to serve in high posts in the Obama administration, like David Hayes, who used to be the Deputy Secretary of the Interior, serving now in the White House as Special Assistant to the President for Climate Policy. All of the names and titles aren't quite as important as the signal. The signal is we are going to put many, many staff in place to tell you that we care about this issue, and we're going to coordinate the federal government in order to work together in a whole of government approach, making progress on climate change using executive power. There are other very significant appointments: Brenda Mallory to lead the Council on Environmental Quality, EPA's new chief, Michael Regan, from North Carolina, the Department of the Interior led by Deb Haaland, a former member of Congress from New Mexico, Jennifer Granholm, the former governor of Michigan, at the Department of Energy, and Pete Buttigieg, who winds up leading the Department of Transportation. These are some very significant cabinet level appointments that all touch on climate, energy, and environmental issues. At the State Department, too, we see some very familiar faces for those in the know, a little bit of inside baseball. Sue Biniaz is back at the State Department working under John Kerry as his principal staffer to develop the strategy for the Paris Agreement going forward. Sue Biniaz, for many who know her, is the chief architect of all international climate instruments on behalf of the U.S., going back 30 years, and Jonathan Pershing, someone of similar experience and status at the Department of State. There are a lot of other appointments we could mention, but the signal sent is extreme competence, deep experience, and ready to go on day one. As Richard mentioned, when the transition began, the people put in place as acting agency officials right from the start were people who knew how to manage the federal government and could hit the ground running. Beyond appointments, there are a number of things that the administration did right at the get-go. Richard.
Yeah, so right at the beginning, the new administration begins on January 20th. They divide their agenda into two buckets: short-term immediate actions, long-term agenda action items. Things they need to get done by midterm 2022, things they need to get done before the next presidential election, 2024, and things, as I said before, that'll take 8 years to get done. I'm going to focus on some of the short-term immediate action items, Jody on some of the longer terms, but a caveat with respect to mine. While the short-term includes some quick wins, it also includes immediate steps necessary to set up those longer-term agenda priorities. So there were two major executive orders put out on January 20th and 27th. The first one here, 13990. For me, this was the most exciting part of their transition, was working on the executive orders. So on January 20th, here's the executive order that came out. This is just right hours after inauguration. I have time today to highlight only 4 prominent aspects of it, 3 quick ones and 1 longer term setup. The quick wins, right? Paris, the Paris Climate Accord. Rejoin the Paris Accord. Trump withdrawal was effective on November 4th, the day after the election. Biden rejoining was effective on February 19th, 30 days after inauguration. The Keystone Pipeline was immediately canceled. That was a presidential permit, the pipeline needed, not an agency permit, no rulemaking. Where the president giveth, the president can taketh away. Trump granted the permit, Biden canceled the permit. In addition, on January 20th, in the executive order, moratorium on all activities related to oil and gas leasing in the Arctic National Wildlife Refuge. As I mentioned before, Trump was trying to sell leases that morning before noon. That ended afternoon. So it was part of the longer-term setup in Executive Order 13990. Among other things, it identified and referred to more than 100 Trump rollbacks to be revisited, the ones that Jody referred to before, the environmental protection rollbacks. Now, this was enormously symbolic, but it was also a setup. It listed them deliberately in an accompanying press release. Every one of those orders. That was designed to facilitate the DOJ motions to stay the litigation, to identify them, to make the courts take them seriously. And here I want to give a shout out to the Harvard Law students who worked on the regulatory rollback tracker, because I can tell you, that's what I used in putting together that list. January 27th, 2021, Executive Order 14008, all long-term setup. A call to action across the government, as Jody will talk about in more detail. No agency left untouched, not just the usual suspects, not just EPA and Interior, and not just regulatory authority, but spending and property clause authority. Property clause, a moratorium on all new oil and gas leasing, both offshore and onshore. We can already begin to see the fruit of this longer-term executive order setup within the agencies. They're taking Executive Order 13990 very seriously. This is the chief executive. This is the president of the United States. And they're doing it far beyond major rulemakings, which Jody will talk about. There are all kinds of as-applied decisions going on right now in response to Executive Order 13990. Here are a couple examples. The Department of the Interior has already reversed some of the Trump solicitor opinions put out during the Trump administration. They don't require rulemaking. The current solicitor can just yank them. And the current solicitor, acting solicitor, is none other than our very own Bob Anderson, here from Harvard Law School, who was nominated yesterday to be the actual solicitor there. He yanked several solicitor opinions, including one put up by Trump, which had dramatically narrowed the scope of the Migratory Bird Treaty Act. It eliminated incidental takes from being unlawful. Well, they're unlawful again. Army Corps of Engineers, Army Corps under Biden has asked for time to review the permit for the Dakota Access Pipeline. Obama administration granted that permit, then reversed itself in the final months of the administration in 2016. The Trump administration turned reversed Obama and granted it. Well, now the Army Corps engineer under Biden is taking a fourth look. Last example, on January 6, 2021, the Trump administration published a rule, an EPA rule, purporting to what they called strengthen transparency in science for agency pollution control rules. It said EPA could not rely on scientific information where it relied on peer-reviewed data, peer-reviewed studies, where the underlying data was not publicly available. Now, it sounds fine on its face, but it was a thinly disguised effort to prevent EPA from relying on peer-reviewed science where, for personal privacy reasons, for decades, you don't reveal the underlying medical data. This rule was widely condemned by the scientific community, including by Harvard President Larry Bacow. In fact, our clinic here was participating in the lawsuit against the EPA. On January 27th, 1 week after the new administration was in, a district court struck down that rule. The new administration, no appeal. Those are quick wins. Jody?
So Richard was emphasizing in the quick wins the kinds of things a president can do essentially by fiat, because there isn't a legal process required for yanking opinions, as he put it, changing our mind on certain kinds of informal guidance. But then there are a raft of decisions that presidents can't execute just by signing an executive order. These are regulations. If a president wants those to change, he's got to rely on the agencies that have the legal authority to go through the elaborate notice and comment process by which they can rescind a prior rule and replace the new rule. And it sounds very laborious, and it is very laborious, but it is the legally required process. So these executive orders Richard described, they are essentially, understand them as a starter pistol. They say to the agencies, please go back and look at your authority, reconsider these rules, which is a nod, nod, wink, wink. Don't just reconsider these rules. We want you to strengthen these rules. And this is what you can expect to come from agencies like EPA, the Department of the Interior, and to a lesser extent, Energy, which has very little regulatory power. But across the board, all the agencies will be looking at their major rulemakings that they can deploy to strengthen climate regulation. And I'll just highlight a few priority actions that you should expect to see from the administration, probably in the next year and a half, certainly by the midterms. You should see proposed rules coming from EPA and DOI and other agencies. The first is the regulation of transportation sector greenhouse gas emissions by setting standards on light duty vehicles like cars and trucks and restoring California's waiver to set its own standards. You can probably expect to see that proposal paired with a package of other things that are coming in the Biden infrastructure plan that will help subsidize electric vehicle purchasing subsidized charging infrastructure, so that the entire package, spending coming from Congress and regulation coming from EPA, will look like a plan to transition the transport sector to lower emission vehicles. So there will be a high profile rulemaking coming about cars and trucks. Second, look for a restoration of the methane rules for methane leaks from oil and gas operations on both public and private land. That will require both EPA and the Department of the Interior to engage in rulemaking. A third thing we can expect down the road is some replacement for what was called the Clean Power Plan in the Obama era and what was called the Affordable Clean Energy Plan in the Trump era, where they weakened these carbon standards for power plants. Now, this was conspicuously absent from the executive orders Richard described. He's right, they were super fun to work on, but also super fun to work on was the agency by agency plan, which the administration had well in advance for the order of the rulemakings, the priority of the rulemakings, what every agency had the authority to do, a very elaborate kind of rolling forward plan for how to implement the executive orders. And that coherent package was well designed before Biden ever put his hand on the Bible and was sworn into office. It tells you what's required to get going quickly is to have this action plan in place, because you only have, the time until the midterm election to say this is what we've accomplished. The final thing to emphasize here is, as I mentioned, the replacement for the Clean Power Plan, which was missing from the executive orders. It's hard to know exactly why the president didn't highlight that in the executive orders, that is, direct EPA to put back in place something like the Clean Power Plan. The best guess I think we have about that is that the administration had announced that it wanted to decarbonize the electricity sector by 2035 already. That was a goal that came from the campaign. And there's an expectation that the administration will propose that Congress adopt something like a clean energy standard to get that done. So it's probably part of the legislative agenda, and it isn't the first rulemaking necessarily that will come from EPA, but I would be looking for that down the road. What will this administration do to regulate power plant emissions of greenhouse gases, given the authority it has under the Clean Air Act? I may be running out of time, Richard, so you can tell me if I am. But the last thing I would just mention is that the White House also is working on reestablishing the social cost of carbon and pricing carbon emissions appropriately. The Trump administration had priced them at something like $1 to $7 a ton. That was a massive drop from the Obama years where they were priced at $50 a ton. They're looking to restore that and have an interim price of around $50 a ton. Why does this matter? It sounds very technical, because if you don't acknowledge the cost of carbon in your rulemakings, you are underestimating the cost of weak climate rules. And if you price carbon appropriately, the benefits of climate regulation are appropriately captured. Richard?
Yeah, thanks, Jody. I'm going to take a few moments here. Jody and I really wanted to single out the Biden administration's footprint on environmental justice. And that's because this has potentially historic significance. So what's environmental justice? The official notion is it refers to fair treatment and involvement of all people, regardless of race, color, national origin, or income, in development, implementation, and enforcement of our environmental laws. And the nation has long suffered from environmental injustice. The environmental standards themselves, as well established, fail to account for the needs of communities of color and low-income communities, in particular because it doesn't address the potential for cumulative impacts in those communities. And enforcement has then, in turn, failed to address violations of pollution control laws in their communities. The upshot is environmental justice communities are disproportionately burdened by harmful, toxic pollutants. You can trace the modern history back to the Memphis sanitation worker strike in 1968, with the national consciousness to this issue first having risen in the early 1990s. With that said, it's never been a first-party issue. Not for a Democratic administration, not for a Republican administration, but it is for the Biden administration. It's a first-order priority issue. During the transition, we were told what the few overriding policy priorities were. There were like 4 of them. One of them was environmental justice. Biden campaigned on the issue. When we had transition meetings of environmental justice, there would be hundreds of people on that meeting, across the government. Executive Order 14008, as you mentioned before, refers to environmental justice 24 times. A strong environmental justice focus to the major appointments administration, which Jody's already talked about, Interior, EPA, CEQ. So what's happening and what should you look for? First, White House Environmental Justice upgrade. There's now a White House Environmental Justice Advisory Council. They were just named a couple of weeks ago. Look at that list. It's a who's who environmental justice leaders across the nation. And I know a lot of them because I served on a National Environmental Justice Advisory Council with them a couple of decades ago. This is not a shy, retiring, acquiescing group. They'll be forceful. They'll be heard. And if they don't feel they're not being heard, they're going to let it be known they're not being heard. And they're going to be working with the White House Environmental Justice Interagency Council of cabinet members. CEQ is now having a major environmental justice upgrade. They'll be led by Brenda Mallory at CEQ. And CEQ is going to be leading the way. CEQ has a chance now to become a major player again, which has not been, in many ways, since 1970s. For environmental justice, there are two things to look for: enforcement and spending. First, enforcement. The lesson in environmental justice is that pollution's pathway will always find the pathway of least regulatory resistance. And that's why you'll have cumulative impacts in these communities. Where there's not sufficient regulation, that's where it's going to go. And then you have a lack of enforcement on top of it as an exacerbator. So what the Biden administration is choosing to do is send an essential message. No more open season on violations in EJ communities. EJ communities will now be targets for enforcement, following the California model and the New Jersey model. How's that going to work? One, CEQ is developing an environmental justice screening device to identify communities which are suffering from disproportionate environmental impacts. Second, EPA will take that screening device and they'll identify the communities and they'll start looking at them for environmental violations. Three, they then refer them to the Department of Justice for targeted civil and criminal enforcement. No longer just environmental justice on top of existing enforcement. Look at your water cases, your air cases, and see whether environmental justice happens to be there and do something about it. No, start with the communities. Identify the communities and figure out what violations are happening there of any kind and go after it. Department of Justice, Environment Division has already rescinded a directive that was done by the Trump administration, which eliminated supplemental environmental projects, including service projects, which are a very important part of EJ in environmental enforcement. Back at EPA, expect EPA to revisit its permitting authority. EPA can account for these cumulative effects. They can impose conditions on their permits, on their air permits, their water permits, their hazardous waste permits, promote and address the issues of environmental justice communities. Title VI of the Civil Rights Act of 1964, it guards against discriminatory impact in federally funded activities. It's never been effectively enforced. It's been talked about for decades. It has massive potential. I'll give you an example. Just a few weeks ago, on March 8th, the Biden administration put on hold a $7 billion 24-mile highway project in Harris County. That's the Houston, Texas area. Why? Because of the impact it was having potentially on environmental justice African-American communities. Spending power too. It's not just regulation. Water systems throughout the United States. Flint, Michigan is just an example of what is all around the country in these small rural areas, often EJ communities, where their water infrastructure is crumbling. Investment funds in environmental justice communities, according to EEO 14008, is supposed to make sure those communities, for some U.S. federal investment, receive 40% of the benefits of those investments. Jody?
So Richard was highlighting for us one of the most striking features of the executive orders, which is the priority now being placed on environmental justice and concrete actions to follow. Another striking feature of the executive orders is the quote unquote whole of government approach to climate change. Now, this approach was begun in the Obama administration, which looked to agencies that aren't your usual suspects to make progress on climate change. So instead of just the EPA or the Department of the Interior, the question is, well, what can the Ag Department do on climate change? What can the Treasury Department do on climate change? What might the Department of Defense be capable of contributing on climate change? And so this orientation to look across the federal government has been moved to kind of an even higher level in the Biden executive orders. And so we're seeing action from agencies that we don't expect to see that much action from. So look for Treasury to establish financial contributions to international climate finance institutions and multilateral development banks in a way that orients the money, directs the money to what we might think of as green projects or green considerations. Think of Treasury with its influence over finance as a climate actor, in other words. Likewise, think of the USDA, agriculture, as with its investments, with its budget, having the capacity to invest in and finance, quote, climate-friendly practices through its conservation program under the Farm Bill. There are ways in which agencies can use their budget allocations, their spending power in a discretionary way to further projects that contribute to reducing emissions, sequestering emissions, reforestation, and the like. So through finance, through investment, steering your discretionary allocation in the right direction, agencies that you don't think of as having any influence on climate change can have an influence. And the final example, the Department of Defense can work on ensuring that all of their bases can operate on microgrids, can achieve net zero emissions at all their bases and with all their infrastructure, can invest in resilience for infrastructure at bases that might be compromised by climate change impacts. The other agencies I just wanted to draw attention to that are re-engaging on climate change that we don't always think about as the first agencies include the financial regulators, the Securities and Exchange Commission, the Fed, the Commodities Future Trading Commission. They are all in one way or another trying to figure out how to use their authority to nudge climate policy forward and to manage climate risk in the financial system. So the SEC, with our own John Coates from Harvard Law School, now heading up the Division of Corporate Finance, is looking for ways to issue guidance or perhaps even a rule that will demand more climate-related risk disclosure from companies so that investors, shareholders will understand the climate exposure those companies face. The Federal Reserve is going to focus on climate risk that banks face. And the CFTC is into the act, focusing on regulating derivatives and their impact on climate-related risk. This is climate change like we've never known it in the federal government, right? This is looking for climate everywhere you can across the government. The other thing to mention that Richard alluded to is the Biden administration, President Biden has elevated, when he's elevated EJ, elevated the whole of government approach, directed the agencies to reconsider rulemakings, directed 40% of the investments to go to EJ communities. This is a highly centralized agenda. The agenda on climate, energy, environment is coming from the White House. It's represented by these two executive orders. And though the agencies have to execute it, you can make no mistake, especially with the appointments of McCarthy and Kerry in the White House, that will create potentially some tensions between the cabinet secretaries who are sitting there with the regulatory power or the discretionary power in their agencies to get things done, and the central kind of organized agenda setters in the White House driving things. And maybe we can talk about that later. Richard.
All right. So what's happening? We got to.
Those were my whole of government.
Yeah, we are. All right. So what's already happened at DOJ and what to look for? First, we have a nominee, be Assistant Attorney General for the Environment Division. There are very few nominees. We don't even have a Solicitor General nominee. We have one for the Environment Division. His name is Todd Kim. His hearing's next week. That's a very important nominee. It makes a huge statement. Remember what I told you a moment ago? The Trump appointee who had the division had devastated morale. He had politicized the division to unprecedented extent, hiring, promotion, litigation. His incompetence was succeeded only by his arrogance. So Todd Kim is the exact opposite, and intentionally so. Fabulous ego to ability ratio, unusual in Washington, D.C. He was a career attorney in the Environmental Division under both Clinton and Bush. He was later DC's first Solicitor General for a decade. He's highly regarded and known by the career attorneys. His nomination being supported by the Bush political appointees to the Justice Department. He went to Harvard College. He went to Harvard Law School. We're happy to say he graduated magna, was at the Harvard Law Review, and clerked for the DC Circuit. He is thoughtful, kind, modest, and respectful. The career division attorneys I'm hearing from, they think they've won the lottery. And to point out, Todd Kim Big Dicey did that. He won $500,000 on Who Wants to Be a Millionaire years ago. So what's happening at DOJ? This is what people tell me. Quote, everyone is feeling freedom. Quote, all Todd Kim needs to do is walk in the door. They have been filing in the last few weeks dozens and dozens and dozens of motions for extensions of time in cases defending the Trump rollbacks. They're trying to buy time to allow the client agents to reconsider their positions. This is all part of the Executive Order 13990 strategy. The Environment Division of DOJ doesn't make policy. They can't just confess error in those cases. They're not like the Criminal Division, the Antitrust Division, the Civil Rights Division. Those divisions don't really have clients. The Environment Division has clients, and what they have to do is represent their clients. And their job right now is create room for their clients to revisit their earlier Trump rollbacks. So far, the courts have been very receptive. They've been granting the extensions. Example, NEPA cases. One of the most extraordinary rulemakings done in the Trump administration was rolling back dramatically NEPA. For the first time, it's been around, these regs have been around for more than 40 years. Every administration accepted significant cutbacks on them. There are cases across the country. They're getting extensions in those cases. The Waters of the United States rules and the Clean Water Act. Again, there are dozens of cases across the country. They're getting extensions. The national monument cases, the Bears Ear, the Grand Escalante extensions, the coal ash cases, the Endangered Species Act cases. They've been doing pretty well getting extensions. But remember, there's some limitations. It's perhaps easy to get 90 days, but we're running up against that. The agencies are need to start to doing something to convince the courts to give anything more, or agree to let them remand it back to the agency. And here, one possible irony, one possible reason why the agency may be a little slow, it's hard to get things going in the beginning. But here, there's so many people in the administration who before were out challenging the Trump rollbacks, they've got conflicts. And so it makes it harder to make some of those decisions when everyone's conflicted out. Enforcement is going to be revitalized. The prior Assistant Attorney General for the Environment Division had put out a series of directives pursuant to Executive Order 13990. The career acting Assistant AG for the Environment Division rescinded them all in early February. Examples, rescinding the one dealing with supplemental environmental projects, a very important tool for environmental justice, rescinded. A directive which made it very hard for DOJ to file in Clean Water Act cases where the states were also filing, rescinded. Where do we expect to see enforcement surges? I think one, classic air and water pollution will be back. We're going to see referrals. It will take time. EPA, Interior, they've got to gen up the cases. It'll take 6 or 7 or 8 months to get them. But look for more than the classic ones. Look for climate enforcement. Look for the possibility of directed enforcement at those sources, which are the largest source of greenhouse gases. And also, as mentioned before, look for an environmental justice litigation initiative, targeting environmental justice communities, working with CEQ and EPA to bring enforcement there. Finally, Executive Order 14008 asks the Attorney General to consider changing the name of the Environmental Natural Resources Division, to consider changing it to the Environmental Justice and Natural Resources Division. Put that in historical context. When created in 1909, it was the Lands Division. A few decades later, it became the Public Lands Division. Then in the late 60s, it became the Land and Natural Resources Division. And then in 1990, when Dick Stewart, my former Harvard law professor for environmental law, was Assistant Attorney General under George H.W. Bush, it became the Environmental Natural Resources Division. It happens every 30 years. Now, 30 years later, I'm thinking a profound change of the name, Environmental Justice Natural Resource Division, to say the kind of moment we have now and how things are different. Jody?
So as Richard made clear, you have a lot to watch, right? Watching just the Department of Justice, the Environment and Natural Resources Division, and the litigation agenda, both offensive and defensive, is a full-time job. But you also, as he alluded to, need to watch their client agencies, because their client agencies are generating the rules, the enforcement actions, and the decisions that DOJ enforces. And the burden on agencies like EPA is crushing. The amount of time it takes to produce these new rules, setting standards for cars and trucks for their emissions, setting standards for the power sector, standards for methane from the oil and gas sector, and the list goes on and on. Or the Department of the Interior enforcing the Endangered Species Act and doing all the things that that agency has the statutory authority to do, at regulating public lands, oil and gas leasing and extraction, offshore and onshore. It's a crushing regulatory burden with an overworked and for the last 4 years undermined staff. And the rebuild project to enable the agencies to do the regulatory work they have to do, the technical work, the analytic work, the economic analysis, it's overwhelming. I cannot overstate it. The third thing you're to watch, not just the litigation, not just the regulatory action, but the third thing to watch, of course, is the legislative agenda that we have not really touched on. And we only have a few minutes. We can take some questions about it, but it's important to appreciate that piece of the Biden administration agenda, because what really this boils down to is the Biden plan is an executive action plan with a spending agenda attached to it. The spending will come through both the infrastructure bill and the tax plan that they've announced to go with it. This will happen through reconciliation because it's all about raising and spending revenue, meaning it can go through the fast track process and can be voted on party lines, no filibuster potential. That's hugely important. The amount of climate energy investment that's going on in the infrastructure bill is stunning. I'll give you just a couple of examples that's being in what's been proposed so far. $174 billion in electric vehicle incentives, rebates, grants, incentives meant to incentivize purchase of these vehicles, but also to establish funding for charging stations and everything associated with electrifying the transportation fleet. $174 billion. $74 billion separately in grid investments. Okay, these are just some of the numbers rolling out in the multi-trillion-dollar infrastructure plan. To go with that, there is a tax plan that the president just announced, which consists of eliminating subsidies for fossil fuels, tax subsidies, and so on, and also extending production tax credits and investment tax credits for renewable energy so that they continue to receive incentives, and finally, tax incentives for long-distance transmission lines. I'm just giving you a few examples of what's going into infrastructure and tax policy, all of which is the legislative agenda piece of the climate plan. Notice what's not here, people. A big plan to cap carbon nationally through a cap and trade system, a carbon tax. These proposals are not the key legislative proposals of the Biden administration. So how to understand what's going on is to see that the president is prepared to use the regulatory powers and the non-regulatory discretion of the federal government to maximum effect, to leverage the international community by rejoining the Paris Agreement and committing the United States to that agreement, which is really a commitment to engage in domestic action, domestic regulatory action, and patch that together with a legislative plan, which is essentially spending, investment, and tax policy. We'll leave it there. And Richard, if you want to make some concluding remarks.
I will. And so much of this all depends, as you looked at today's morning headline.
Who's the man? Who's the man? Joe Manchin. I forgot to mention. This whole legislative agenda, of course, runs into the fact that once you're in a closely divided Senate, even when you're proceeding on a party line vote, you have to get everybody to vote your way. Every senator essentially can hold this up. And Joe Manchin is the key senator in the most powerful position at the moment because he chairs the most important Senate committee on energy and natural resources. And he is the guy that is ending up making the deal with the administration on what he will support in the infrastructure bill. So what's interesting is the negotiation isn't really with the Republicans. The negotiation really is among Democrats in order to get all 50 senators. And of course, in order to hold the House together to vote for it too, because there are slim margins in the House. Richard, do you want to add about Joe Manchin?
Yeah, not at all. I mean, we saw this morning's headlines in the New York Times, Washington Post overnight about Manchin, quite well aware of the leverage that he has. Right. So just a few concluding thoughts, and then we're looking forward to some questions. Needless to say, a lot on the agenda, right? It's pretty exciting. Actually, it's as exciting now as it was depressing for many of us 4 years ago. There's an enormous amount of work to do. Time's not fungible. Issues like climate, time makes a difference, a big difference. And we've lost 4 years at the very least. But at the same moment, what a time for our law students and law students everywhere to make a difference. What a time for environmental scientists, for environmental economics, environmental engineers to contribute. It's a time to make history. Jody?
The last thing I would add to that is we've talked, of course, exclusively about the Biden administration's plan to leverage the government, but I think the private sector is playing an ever increasingly important role in climate and environmental regulation and sustainability. And you see some very important leadership coming from the private sector that I want to acknowledge. And I think there is no path forward that doesn't include major commitments from leading private sector institutions to do more to reduce their carbon footprint, to invest in renewables, to assume leadership positions, to support government policy, to be part of the future transition to clean energy. You see that happening in the utility sector. You see it happening with all the announcements from the auto industry announcing a move to electric vehicles and targets being set by companies like GM to go all electric by certain dates, by 2035. These are really important commitments. They're not binding, but they're really important commitments. And I think that what's going to be required moving forward for the Biden administration to succeed in its ambitious agenda is to partner with the private sector and pursue its regulatory agenda.
Great. All right, Hannah. Hannah's curating and finding our questions for us. Hi, Hannah.
Hey, everyone. We have a bunch of great questions already. I'm going to consolidate a few of them. We have a bunch of questions first on the Clean Power Plan and the Affordable Clean Energy Rule. One is just asking, do you see any meaningful differences or anticipate meaningful differences between the Obama-era Clean Power Plan and whatever rule the Biden administration is going to come out with? And similarly, EPA, another question, this is from Jim Stock. EPA remains obligated to regulate CO2 emissions, and it's going to take 4 years to replace the Clean Power Plan. So how does EPA balance developing that plan as a backstop if they're not going to get the clean energy standard in the American Jobs Plan?
So
go ahead.
Let me start and then Richard can chime in. I'll just be really brief on this. The fact that the DC Circuit Court of Appeals rejected the Trump administration's view of its authority to regulate carbon for the power sector, basically it said your very narrow view of your authority to only regulate unit by unit by unit as compelled by the Clean Air Act is wrong. And that's it. It's not compelled by the Clean Air Act. That doesn't tell us anything about how EPA will move forward in the future. EPA can't, I think, just automatically adopt a Clean Power Plan 2.0, which would basically reinstate the Obama era approach. That approach looked at the grid as a giant machine and said, where can we reduce emissions on the electricity grid by basically substituting renewable energy for natural gas and coal. It was essentially a look at this as interconnected and look for emissions reduction opportunities. That was the legally controversial theory of EPA's legal authority. And we don't know how that theory will fare. If the administration now, the Biden team, were just to re-adopt it, it could be legally risky. And we confront a Supreme Court, of course, that has a new composition. Richard can comment more on that. 3 new conservative justices, changes the complexion of the court very significantly. It was going to be an uphill battle already with the Obama era approach. I think we all think it would be even more of an uphill battle now. So the agency is going to have to be very careful about how it structures any replacement rule.
Yeah. Now, uncharacteristically for me, I hadn't uttered the word Supreme Court during our entire discussion, but Jody's right. That's the elephant in the room when it comes to the Clean Power Plan. It's a great DC Circuit win for the Obama administration and rejecting the Trump administration. They upheld basically the Clean Power Plan while rejecting the Affordable Clean Energy Plan. But you don't see anyone racing from the Biden administration to have that case appear before the United States Supreme Court. It's a very different court than we had at the end of the Obama administration. Then it was all up to Justice Kennedy. Justice Kennedy is not there anymore. If Hillary Clinton won in 2016, it would have been Merrick Garland added to the court. We probably would have a working progressive majority, which might have been like the DC Circuit opinion in this case, but that's not where we're at. So what you're going to see them try to do is get back to the same kinds of goals and levels of reduction that the Clean Power Plan did. And the market has done a great deal of work on its own since then, but without the same legal rationale. But instead focusing more on the text, as the current court would want, but then letting industry comply by doing whatever they want to do, and they'll go back to the Clean Power Plan. But it won't actually base the emission reduction level on it. It will instead base on things which are more textual, and the industry will, I think, move and do Clean Power Plan things like to get there.
Let me be really clear about this. I know we have other questions, but this is such a high value, important issue. The ambition of the set of standards the Obama team adopted, which would have reduced, emissions 30% by 2025, whatever it was, which has been accomplished, that level of ambition, you can't get to something super ambitious if you don't take that approach that treats the grid as interconnected and substitutes cleaner energy for natural gas and coal. You can't get there. You will have more modest standards if you don't take the very ambitious Obama era approach. But you still can push for something more ambitious than you might have if you recognize what technology can accomplish. If you take the lessons of the last 4 years and say, look what the market can do. Look what technology is available, and you can be more ambitious than you might have been 4 years ago. So I guess what I'm saying is there's room for EPA to push the standards, but you can do much, much more if you take the legal theory of the Obama era. And I think taking the legal theory of the Obama era at least presents some risks that they're going to have to consider very carefully.
Yeah, and you start adding other measures to make wind and solar more accessible, remove barriers to them,
right,
promote the technology. The market's going to do a lot in this area. And the bottom line is we want the reductions to happen. We need to.
And that's what they're doing. You have to put this all together with the infrastructure plan and the spending, the investment. What they're doing is the incentive side of this. They're trying to incentivize this shift and not do it primarily through regulation.
Yeah. Hannah.
That's a great transition to another question. We've had a lot of folks ask about carbon taxes and carbon caps. One is looking at the international side. Do you think the Biden administration would ever support an internationally mandated carbon tax? Another question related but distinct. You had mentioned that a carbon price or carbon cap will not be part of the Biden administration's agenda. Is that because of the political difficulty to pass that legislation, or is it just not a part of the way that they're looking at trying to reduce the amount of carbon in the atmosphere?
Let me say this, and Richard can chime in. The carbon tax looks like it would be the most sensible thing imaginable right now. You have to find ways to raise revenue to pay for your massive infrastructure package. How could you raise revenue? Let's see. How about taxing carbon and raising billions of dollars? It just seems like a no-brainer. Not to mention that the oil and gas industry leadership and many other corporate sectors have endorsed a carbon tax. If they're going to see climate rules, they'd rather see a carbon tax be the form of policy, and yet not really looking like it's viable. And why is that? I think the politics of a carbon tax are very gloomy right now. The Republicans will hammer Democrats for energy taxes. There will be remember the BTU tax in the Clinton administration. For those of you who are old enough, it's a really politically risky. To be the party that imposed a brand new, quote unquote, what they'll call it is an energy tax on consumers, especially coming out of COVID. It is a very tricky thing. And many people on the Democratic progressive side don't like the idea of carbon taxes because it looks like a license to pollute, a license permission. They'd rather see a cap. So I see right now, the pathway for a carbon tax doesn't seem very open, but I wouldn't rule it out forever. Their politics might realign. I think a cap, nobody's talking about cap and trade anymore. So I think where we find consensus is everybody wants to spend on infrastructure. Even when Republicans say they oppose it, they all want roads and bridges rebuilt and airports rebuilt in their districts and in their states. So there is bipartisan support, whether they're willing to acknowledge it or not, for massive infrastructure spending, bipartisan support for energy efficiency, bipartisan support maybe for a clean energy standard, maybe down the line. But right now they're doing half the clean energy standard, which is the investment subsidy part. The regulatory part that would set caps on fossil energy might come later.
Yeah, I mean, the tax it's such a sensible approach. It really is. And there are a lot of moderate Republicans, traditional Republicans, Bush Republicans have been on the record in favor of it. It's just not where we are politically. And you can't do it through international indirect because nothing can become mandatory. We can't sign an international treaty which agrees to mandatory unless it's ratified by the Senate with the Paris Accord. So unfortunately, it's not going to happen, the tax approach. If it did, it would be a very nice approach and solution.
We also have a number of questions on insulating Biden action from future administrations, given that we don't know what's going to happen in 2022, 2024, and these regulatory reforms take a lot of time. Again, I'm going to kind of smush a bunch of questions into one. One from Eric Litzenstein about sort of how you make decisions in litigation on when the Biden administration should seek a voluntary vacatur in pending cases, addressing rules that came up during the Trump administration, versus sort of broader legislative priorities and where you see the administration putting its political capital, given they've committed to environmental justice, to union jobs, to buying American. Where do you see them trying to channel their political capital when it comes to legislative action that might be more longstanding?
Jody?
There's a lot there, Hannah. So the first thing, I think I'll just address the legal durability part. Richard, maybe you want to speak to the litigation part. The question often comes, well, how can you inoculate what you're doing now from future rollback? Are we all just going to see roll back, roll forward, roll back, roll forward? The pendulum swing will just continue. And I'm afraid to say, as an administrative law professor, there is no surefire way to inoculate rules from being changed later. I mean, that's the nature of executive action. As long as you follow the legal procedures, you can rescind a rule and replace a rule. So we are bound to see pendulum swings in the future. I think what the administration can do is make these new regulations as legally resilient as possible by making sure they're well-founded, they have a good legal basis and legal theory, that they're textually rooted and anchored in statutory power, that they don't look like they're making up statutory authority based on the penumbra, if you will, that they're textually based, but also that they have very strong records that supports their technology decisions, strong economic records. So they're really as bulletproof as they possibly can be going into litigation. That, at least, I hope, increases the chances of surviving legal challenge. But the idea that you can set in stone regulations that a future administration can never change, not possible. And that is why we need Congress to be in the game and adopt a modern climate bill. But since we're not there yet, the best we can do is use the executive power that we have.
Two things, and obviously Jody's completely right that if you do it by executive branch action, you can undo it by executive branch action. There are ways you can try to make it more durable, though, a little less likely to be overturned. One is have a really good rulemaking record. Have a rulemaking record based on science, technology, economic analysis. That's why the Trump administration flailed for 4 years in trying to undo the auto efficiency rules, because the rulemaking record was so good and so deep that they made so many mistakes in trying to undo it that it took them much longer than they wanted. And then what they came out with was flawed. It would have been thrown out by the courts. So you do a really good rulemaking record, it can't just be undone. It's done on facts and science, not just on legal interpretation. The other thing is get them in place as quickly as possible. Get industry to start investing and realizing the benefits of it. Once you have industry that says, we can live with that, actually, we can make money off of that. We can make profits. This will work for us. Once that happens, you lose a lot of the industry sort of opposition to it. That too was happening with the auto efficiency rules. It was happening with the methane rules. There was industry not supporting what the Trump administration wanted to do to change because they said this worked for us. The mercury rules have been in place. People had spent their money. They didn't want them to go away. So even when the Trump administration reversed the mercury finding, they said, but we're not changing the rule. Why? Because industry didn't want the rule changed. On the question about pending litigation, on there, the Department of Justice, by tradition, be very reluctant to just unilaterally confess error or seek vacators. Courts don't like that until the agency shows its seriousness about revisiting the issue. The agencies do more than just a presidential listing of it reconsidered. the agency actually starts to put out some notices and some proposals on what it's doing, then they can ask for remand back to the agency. And then it will depend on what judges they happen to have, and what the interveners say. But they're not going to win those things until they lay the groundwork at the client agencies.
And speaking of those agencies and the whole of government approach, we have a question about where state and local governments fit into that approach. And so what do you see the Biden administration doing in terms of interacting with those governments to implement its climate agenda?
Well, I guess what I'd say right now is I think they're trying to send the state and local governments an awful lot of money to spend on infrastructure projects and to incentivize them to build things like transmission lines and site them and approve them. A lot of the authority to transition to cleaner energy sources rests with state governments. And so what does the Biden administration got to do? It has to create attractive incentives for them to say, here's a bunch of federal money to spend on these things. If you want the federal money, you've got to spend it on these things. So I think that primarily is the strategy that they're pursuing. It's not clear to me yet what the state role is going to be in any of the big signature rules, like the power sector rule. If they issue a new power sector rule, there's always a question of how the states will be built into that, whether the states will be delegated a lot of authority to implement that or not. But they're obviously essential to any clean energy agenda. Most of the action is happening in the states right now. But what the federal government is trying to do, remember, there are essentially clean energy standards or renewable energy or portfolio standards in many, many states, a majority of states. So what the Biden administration is trying to do is take what's already happening in the states and create a federal level policy to put the wind underneath it, to create a kind of federal minimum. So if anything, they're building on state leadership in a way, which is often the dynamic, but they want to create a kind of national approach, national program.
Absolutely. And that goes back to the durability question we were asked before. One way to make it durable is through 50 states and not just through one national government, as we saw happen for the past 4 years. And right now, the Biden administration, I mentioned environmental justice, they're going to see what California did on environmental justice. They're seeing what New Jersey did for environmental justice, and they're going to steal it. They're going to steal it, learn from it, and borrow from it. They're looking at the states on the portfolio rules across the states. So it's incredibly important what the states are doing. On adaptation, we've been talking about mitigation. On climate adaptation, the action's with the states, and they're going to use a lot of that money for climate adaptation, dealing with the fact that we're going to have a lot of climate change right now and trying to minimize the adverse impact. The states are always an important part. I think of it as an upside-down pyramid. The federal government's at the bottom, but most of the action is happening with the states. And the federal government can support what the states are doing, but it can never substitute for it.
Speaking of cooperation and national implementation, we also had a number of questions on bipartisanship and President Biden's focus on bipartisanship. And so what environmental policies do you think the administration is likely to promote that will also garner support from Republican members of Congress?
We laugh at the notion of bipartisanship at the moment. I think this administration is looking very, very savvy and smart. I mean, Ron Klain, the chief of staff, and the rest of the team, I mean, they're just the savviest operators. And you can see it because they're going big on their infrastructure plan, and that has a huge climate energy component in it. And they're going to do it through reconciliation after meeting with the Republicans and, making the effort to attract Republican votes. They all know that it's going to happen through reconciliation because the Republicans won't vote for it. Even though, as I say, behind the scenes, many of them, I'm sure, are pleased about the amount of money that will be flowing to their states and to their districts. So when we talk about bipartisanship, I think the administration knows that it has to make an effort at it, but is not going to get hung up on it. Is not going to waste a year or two trying to negotiate with Republicans, and then in the end, the votes won't be delivered. They're going to use reconciliation, and I think it's just a very smart and savvy approach. In terms of some policies that should be bipartisan, like dealing with very bad water and air pollution problems like lead contamination, you would think that Republicans and Democrats alike would support essential public health measures. I'm not sure that's true, but you would hope there would be bipartisan support for rules that are so crucial to public health, especially protecting kids, for example. But I'm not sure how much of that we'll see publicly acknowledged.
Yeah, I mean, it's a head scratcher. So many of these issues in climate, there's no reason they should have any partisan valence at all. I mean, at most, they could be downstream, downwind, upstream, upwind. Well, that doesn't work for climate. That makes sense. But this current red and blue divide on these basic issues of public health, it's just insane. It's happened since we've had it since 1993, the midterm elections in 1992. Before that, you actually saw bipartisanship on these issues. We just haven't seen it. It makes no sense. I don't think, unfortunately, we're going to see environmental issues solve that problem. They could have, but they haven't. There's a lot of empirical evidence which is why I think Jody's talking the savviness of not trying to spend a lot of time on it, which is a shame. It should be Mitt Romney. I mean, there are a lot of Republicans out there who are moderate, not as many as there used to be, but there's still the base certainly has a lot of moderates on these issues, but the elected leaders don't, and that's going to be back to districts and how they're gerrymandered and the political finance. But we're just stuck with it right now, and it's really awful. It's inexcusable. But on the climate issue, you can't wait.
Well, there are two things I will say that tend to be quite bipartisan in this climate and energy space, and that is energy efficiency. George W. Bush supported and promoted energy efficiency, and the energy bill, energy legislation passed during his administration, and renewables attract a significant amount of Republican support, especially from states where there are big renewables. I mean, Chuck Grassley supporting renewable energy. So on those issues, I think the administration is going to be smart and savvy and say, we want support for spending and investment and subsidy on energy efficiency and renewable energy. And I think they'll find a lot of support there. But otherwise, anything regulatory, anything that could be framed as an energy tax, anything like that, I think is going to run into trouble.
I have time for one more question. And I apologize to everyone who we didn't get to your questions. We had a couple questions also come in on environmental justice, so we can end on that. One coming from the enforcement side, what changes do you think you'll see at DOJ when it comes to upping environmental enforcement around pollution, and specifically changes at ENRD? Is this going to be a civil rights issue? Who's going to be involved? And the other question is probably more on the spending side and any intersection we might see between environmental justice and climate adaptation.
Yeah, I think on both scores we'll see a lot. At DOJ, I think we're looking to see the Title VI Civil Rights Act stuff. That is done by the Civil Rights Division. There's a whole little office there. I think they're gearing up. That's my understanding. They're gearing up for that, to do that again. And then I think in the Environment Division, I think look for an environmental justice dedication and litigation initiative in that area. That's what I'd be looking for both the Environment Division and the Civil Rights Division. I'd also expect you could see that it might be like the Office of Environmental Justice at the Justice Department, akin to the Office of Tribal Justice that Janet Reno created during the Clinton administration. I think looking at all things the DOJ does in that area, because it's not, environmental justice isn't just the Environment Division, the Civil Rights Division. It's the Civil Division. It's where airports are cited. It's air traffic noise. It's trucks. It's truck transportation. It's truck noise. It's truck exhaustion. Some of that stuff is done through the other parts of it. And I think Merrick Garland cares a lot about this issue. And I think we're looking for an Office of Environmental Justice, which is equivalent to the Office of Tribal Justice. If they do that, I look to see if they do what the Environmental Office of Tribal Justice has done. And that put in every U.S. Attorney's office around the country an environmental justice liaison officer, someone who the local communities can reach to and will reach out to them. That's what I'm looking for. In terms of environmental justice and adaptation, absolutely. That's part of what Jody was talking about. That's part of all the infrastructure work that's going to be needed around the country. And the administration has dedicated that for a lot of those investments, a lot of infrastructure, the 40% of it, of the benefits will go to EJ communities. And that's part of the screening device being done by CEQ.
You know, before we leave you all, I just want to say a couple quick things about what to watch, because Richard was talking about what to watch, and I think a couple things we haven't touched on. One is watch the process that leads up to the meeting in Glasgow, Scotland, the next COP meeting for the Paris Agreement. We will have a summit here in the United States of the major economies. I believe it is in April, and you will see the sort of presentation of the first glimmers of what the United States is prepared to pledge to the Paris Agreement. And hopefully you'll see us get back on track and be very ambitious. That'll be a big moment to watch for. But really, you got to watch the clock. We are in trouble. The midterms are around the corner, and the projections are that the Democrats will lose the House. And that is very significant. And so getting this infrastructure package through and getting the Recovery Act through, these are the big plays that the administration has to get done before the midterms. The prospect of any major legislation after that in this Biden administration, I think, is very slim. And so we will come back to what can the agencies, the federal government and Department of Justice through its enforcement and defense and offense capacity do together. That's where the action will be on climate and energy.
So when Jody and I have done these talks, which we really enjoy doing, it's so good to do another one today, we always close it with a fist bump. So Jody, I think if you use your left hand, I use my right hand. No, other way. There, fist bump. All right. Thanks, everyone. Thanks for joining us. It's a real pleasure. We look forward to seeing everyone back on campus in the not too distant future. Take care. Thanks.